This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about Chutzpah, where a claim from a killer seeking compassionate release from prison was refused because there was no compelling reason to release the convicted arsonist and murderer. Now, chutzpah is a Yiddish term that means unmitigated gall, and it is usually defined as a person who is convicted of murdering his mother and father and then seeks mercy from the court because he's an orphan. Yet a person with absolutely no compassion for his many victims, with an expression that defines chutzpah, sought compassionate release from his 110-year sentence in United States of America versus John T. Vesey III, a March 2, 2023 decision of the United States District Court for the Northern District of Illinois. Vesey, while currently serving a 110-year sentence for wire fraud, arson, and felony by fire, moved the USDC for compassionate release because he was fat, had high blood pressure, and was afraid of the COVID pandemic. The USDC, in considering his request, noted that throughout the 1990s, Vesey devised various multiple deadly schemes to cause losses and collect insurance proceeds. Among other offenses, Vesey fraudulently obtained $959,849.47 in insurance proceeds from a car accident involving his first wife, from the death of his first wife, and from arson for profit fires to 3 of his residences. He tried to obtain an additional $1.3 million in insurance proceeds by attempting to kill his second wife and then infant son in a house fire, and he schemed to fake the death of another woman and her sons. On March 6, 2001, following a 6-week trial, a jury found Vesey guilty on 18 counts, and consistent with then binding sentencing guidelines, the United States District Court sentenced Vesey to the statutory maximum of 110 years imprisonment. Vesey argued in his motion that several factors justify a sentence reduction, including his health conditions, ongoing risks associated with COVID-19 in the federal prison system, alleged sentencing disparities between him and other offenders, his purported rehabilitation, and his preparations for reintegrating into the community. On July 6, 2022, Vesey submitted an updated motion in which he discusses COVID-19 risks, his ongoing health concerns, and his recidivism risk level. As a general matter, a federal court may not modify a term of imprisonment once it has been imposed. The court may reduce a sentence if extraordinary and compelling reasons justify release. The kind of extraordinary and compelling circumstances contemplated by the statute includes some new fact about an inmate's health or family status or an equivalent post-conviction development, not a purely legal condition or contention for which statutes specify other avenues of release. Legal arguments that an initial sentence was made in error do not qualify. Vesey pointed to his health conditions, including hypertension, atrial fibrillation, and obesity, as circumstances justifying a sentence reduction. Vesey may not use a motion for compassionate release to argue that the court's original sentencing decision was incorrect, and in addition, Vesey offered evidence of his rehabilitation while in prison, but rehabilitation alone is not an extraordinary and compelling reason for release, nor can rehabilitation render otherwise ordinary circumstances extraordinary. Also, the fact that Vesey has now spent several years in prison and has made efforts to prepare for life outside of prison, I guess after he serves 110 years in jail and is almost a 200-year-old person, does not qualify as an extraordinary and compelling reason that could justify his release. Even if Mr. Vesey were to present an extraordinary and compelling reason for compassionate release, the court would still deny his motion under Section 3553 paren A close paren factors, because consideration of even one statutory factor may show that the others do not matter. The first such statutory factor, which addresses the nature and circumstances of a defendant's offenses and personal circumstances, strongly militated against a sentence reduction. His crimes were shocking. Vesey killed his first wife to collect insurance money. He tried to kill his second wife and then toddler son. He torched multiple houses and purchased life insurance coverage on another woman shortly before he was arrested, all to collect insurance money. Vesey carried out these extraordinarily serious offenses over several years, destroyed numerous lives, and caused enormous emotional and physical pain and monetary damage. Even if Vesey had presented to the court an extraordinary and compelling reason for his release, consideration of the statute alone would provide a sufficient basis for denying his motion, and that motion was denied. In my opinion, Vesey is proof that insurance fraud is a violent crime. He managed to murder and commit arson for profit and insurance fraud for years before he was arrested, tried, convicted, and jailed on a 110-year sentence. Vesey defined the Yiddish term chutzpah by asking to be released because in prison he became obese, created a situation where he had high blood pressure and suffered from arterial fibrillation. The United States District Court wisely refused his request, since his condition was neither extraordinary nor compelling, setting forth reasons for release. In fact, it was the opposite. A compelling reason existed to keep him in prison forever, to protect anyone who might come in contact with him outside the prison system. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. And you can subscribe to the blog by clicking on the location setting forth an availability to subscribe, as well as to the videos on YouTube and on rumble.com. If you found this video or the blog posting to be useful to you, please tell your friends and colleagues so that they can also subscribe and receive the special information available on the more than 4,450 blog postings available free, as well as the more than 600 videos available free to anyone who asks. Thank you for your attention.